Hi, I'm Asha Thomas. I'm an immigration lawyer and I'm an immigrant myself. I set up Global Immigration Solutions with my business partner Robin Molyneux in 2006. And in this brief video, we want to give you a broad overview of the procedures involved in the appeal process. First of all, not every application is going to carry a right of appeal. If you're overseas, then you'll only have a right of appeal if you're coming to the UK to join family who are settled in the UK or who have refugee or humanitarian leave in this country, or if you're coming to visit really close family. If you've applied from within the UK, then you will generally have a right of appeal as long as you submit your application while you still have a valid visa. Appeals work to very strict deadlines. If you're overseas, you have 28 calendar days from the date you receive the decision. So that's the date that you sign for it. And if you're in the UK, then you need to lodge your appeal within 12 working days from the date of the refusal. 2 days are allowed for the post to reach you, and you have 10 days after that. It is important to be aware of these deadlines because if you lodge your appeal out of time, the tribunal may not accept your appeal. The tribunal charge £80 for a matter to be decided on the papers and £140 for an oral hearing. You'll find out why you should always ask for an oral hearing in our free guide to strategies for winning your appeal. If you've been refused by an entry clearance officer overseas, the tribunal will send the appeal to the embassy that refused you and will give them a deadline to look at your application again and see if they want to overturn their original decision and issue you with a visa, or if they want to stick to the decision and send the matter back to the UK for an immigration judge to make the decision. If you're in the UK, then the UK Border Agency won't be looking at your application again, and the tribunal will just set a date for the hearing. All immigration appeals are heard initially in the first-tier tribunal, which is the lowest level of the court system in the UK. The decision on your appeal is made by an independent immigration judge, and I'm sure that you will be very pleased to know that the immigration judge will not be dressed in a scarlet robe and wearing a wig like the gentleman in our picture. Immigration judges in the first-tier tribunal are generally either barristers or immigration lawyers, and it would usually be a single immigration judge who makes the decision. The other official who's going to be usually present at an appeal is a person called a presenting officer, who works for the UK Border Agency and whose job it is to argue the government's case as to why it was the correct decision to refuse your application. The presenting officer acts for caseworkers in the UK Border Agency as well as for entry clearance officers overseas. This first appeal is the best opportunity you have to put forward all the evidence and raise all the issues that you want to be considered, including all the human rights aspects of your case. And this is because any challenge to the immigration judge's decision after this hearing can only be made on technical points of law and not on the facts of your case. Those can only be put forward at this appeal.